Good morning, gentlemen.
Good morning.
Good morning.
Glad to have you here. Gaslowitz Frankel LLC. Craig, Adam, I'll let you guys take the stage right now. Tell us a little bit about your firm and the types of law that you work in.
Gaslowitz Frankel does what's called fiduciary litigation, which is trusts, estates, and business disputes that are dealing with money, whether they be a will or someone worried about a family business, and somebody's essentially taken something or suspected to have done something wrong. And we're going to deal with the dispute side. How do you resolve it? Hopefully by strategy, maybe by mediation, ultimately by a lawsuit.
Do you guys ever step in prior to litigations? Do you ever come into a meeting with new partners, or perhaps a family is setting down and they're going to pass on a legacy business or take a look at that trust? Or do you primarily step in when litigation's already the end all?
That's starting to happen more now. For the first at least 20 plus years, we didn't get called until after a dispute had arisen and either there was a lawsuit pending or about to be filed. So it didn't happen. But as our reputation grew and we give a lot of speeches each year to the lawyers in the bar and to the community at large about how to avoid estate litigation, how to anticipate problems that might arise in your estate planning, and how to sort of plan around those. And the more we did that, the more we started getting calls from both attorneys in the estate planning field and bank trust officers to come in and advise them about potential problems they see, about an estate plan they're doing where they suspect there might be a conflict, or where they know there's a dysfunctional child or a family that doesn't communicate, and to help them work through the potential problems they might have, and perhaps take the plan they're doing and maybe tweak it so that it doesn't end up in the conflict that they anticipate. But this comes up particularly in the context of our clients who have businesses, family businesses. There's often some family members working in a business, other family members who are not, and so potential conflicts arise a lot in the context of how do you transition a business from one generation to the next. And so a lot of estate planners who deal with owners of closely held businesses contact us to say, we know we're going to have this problem. We know we're going to have a problem when Generation 1 retires and parts of Generation 2 take over, because the other parts of Generation 2 are going to feel slighted. They're going to feel like their sibling is mismanaging the company or taking too much compensation out, or the stock distribution isn't quite even, or there's the ability of one to outvote the other. And a lot of times, people who are not involved in the business, the other siblings might end up with more stock because the one that's in the business is just one of, say, 5 children. And it's easy for the non-business operating siblings to vote the other out. So you've got to work around that. You've got to either reallocate your estate or find some other way to make sure the business doesn't implode as soon as Generation 1 retires.
Gaslowitz Frankel LLC. We're talking about wills and estates and trust disputes. And I was going to ask you, what is one of the more common problems and issues you see and that you have to litigate?
Probably one of the biggest areas of dispute involves the poor choice for a fiduciary. Either the wrong person that you've chosen as a trustee of your trust, or the wrong executor of your estate. A lot of times it's the wrong choice, not because that person isn't qualified to do it, but because that person is somehow a lightning rod for conflict within a family. So if you name your oldest son as the trustee of the trust and he doesn't get along with your new wife, you're going to have problems. That often is the biggest problem.
And you're going to see that, by the way, not in what we call in our industry blended families. 50% or more of all families will have a second marriage or children from a prior marriage. It's just the way our society is. So you would logically anticipate those kinds of problems. But it actually happens in I don't know what the right word is, original families, because the dynamics are different. We are now living a lot longer. The demographics from my parents' generation, where they had a life expectation at birth of about 60 to 65, a life expectancy at birth today is 85 to 88. So even children who are watching, or grandchildren who are watching, are going to say, if we spend this much money on parent number 1, there'll be no money left over for parent number 2. Or, and I shouldn't say this, but it's true, or for me. And so that's where the conflict starts to arise. And when you put in people that can't deal with it, it's difficult. One of the most common setups that we see is surviving spouse and oldest child. Well, the idea that they would balance each other out.
As co-fiduciaries.
As co-fiduciaries. But they're not going to balance each other out. They're going to be a conflict with no way to resolve it. And every time one wants to spend money, the other will suspect. It puts them in a position you never want a parent and child to be in.
This may be kind of an odd question, but I'm going to assume that you see this every single day in your business, and that is greed. Greed must be a big part of what you see, and probably at the basis of a lot of the disputes you see.
I would use yes, the answer is yes, but I would use the word entitlement. Everybody believes if their parents are wealthy, or their dad or mom own a very big business, they're entitled to it. And the truth is they're not. Not under the law. The law says very clearly, you or I can give our money to anybody.
One of the big issues we see are, besides poor choice of fiduciaries, is powers of attorney. We see a lot of people giving out powers of attorney to their, either to a spouse or to a child or to a trusted friend. And those powers of attorney are often not very well thought out. They're supposed to be used in case you become incompetent and can't do something for yourself. But a lot of times they get abused by people who take the authority with that power and start either mismanaging assets or transferring assets outside of the ownership of the principal. So
once somebody's in that role, Adam, is it hard to replace that person? Is it a long, complicated process, or is it? What do you have to prove if you're saying that they're not doing their responsibilities correct? What do you need to do to try to replace them if they're not doing the job correctly?
often people don't know that it's being abused. So if you've got an elderly parent with a number of children and one child has that power of attorney, the other children often don't know what's going on until it's too late. So a lot of times the problem isn't replace them, the problem is finding out in enough time to do something about it. Once you've found out, there are various ways that you have of freezing assets while you try and remove them. But court intervention is often needed if the elderly parent is too incompetent to sign a new power of attorney. And so court intervention is slow. I mean, you can often get injunctions that will freeze things quickly, but actual removal could take a while.
What we suggest as a tip is to use the Reagan phrase, trust but verify. When you do your documents, don't tempt people. There's two types of people who steal or do things wrong. It's the predators who come after our parents and our elderly, but it's also the opportunists. People who just see it, they take a little here, take advantage there. Write your documents, think about this to not give the opportunities.
Georgia allows you to put in your will that the executor or trustee is not required to account and is not required to post bond. And a lot of times lawyers do this because it makes things easier for the trustee or the executor. It makes things cheaper, you don't have to buy a bond. The problem with that is you're not really making things that much easier. Bonds are not that expensive, and accounting is something they ought to be doing anyway, so providing it shouldn't be a big deal. The problem, though, is if something does go wrong, if you've chosen badly, without a bond, there's no way to collect. So if you've got a bank who's a fiduciary, banks are bonded. If they do something wrong, they have a deep pocket, you can collect it. But if you've named an individual, a child, a friend, your accountant, whoever, and they misappropriate assets or they invest them poorly or they do anything else that's improper, if there's a bond in place, at least there's a way to recover. Because often, like I said, you're not going to find out about it until after it's all gone. And when it's gone, it's gone. That's the thing that most planning attorneys can change in their documents right now and save an awful lot of grief and heartache.
Do you all advise a lot of family members who may not have the power of attorney to go through forensic accounting and kind of hold that executor or whoever does have power of attorney accountable for their actions?
Well, the answer is yes. A lot of wills say that you don't have to do an investigation.
Right.
And you may not choose to, but yes, if you have an estate and you see that you think a power of attorney has been taken advantage of, then you would try to hire a forensic accountant. The problem you have is the choice of the person who's going to be your executor is almost always the same person who abused the power of attorney. So it's kind of like the fox looking after himself. So you gotta, it's a hard thing to do. The better answer really is to do accountings along the way. Right. I do have one tip that kind of goes with that. If you've got a child who wasn't particularly good with money during his or her life, why name them to be a fiduciary or an executor or trustee? And having a co-person doesn't help. Right. Having a sibling that they always fought with to now say, oh, you're not doing it right. And there is kind of, we see it over and over and over. When families have disputes at the end of life, when they're dealing with inheritances, or they revert back to their childhood relationships. So I cannot tell you how many times I have heard they always do that.
How often do you all actually become a therapist in these family disputes as opposed to their attorneys?
Every case.
Yeah, every
I saw that answer coming.